Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from the Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to themurthy.com for contact information. From the beginning, Murthy.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The Murthy.com site provides you with latest and cutting-edge information on US immigration law firms and policies, explained in terms you don't have to be a lawyer to understand. Today's topic is the H1B FAQs. We will continue the knowledge session along with this, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello, Ms. Murthy.
Hi, good evening to you, attorney, and good evening or good afternoon to all of our viewers all across the globe. It's great to be here as always.
Right, it's always a privilege to host you, Ms. Murthy. We love your energy. So, do we have any latest immigration updates?
Since we spoke last week and had this interview, there was the U.S. Department of State released the visa bulletin with the November 2021 dates. And as many people have noticed, the EB3 dates have actually gone backwards and the EB2 is moving forward. This is consistent with what Mr. Charles Oppenheim, the chief of the Immigrant Visa and Control Unit at the U.S. Department of State, that is primarily responsible for movement of priority dates based on input, both from the USCIS and from Department of State, had told us back in August and September that because of the tens of thousands of cases that had been filed last year, October and November of 2020, that this year, sometime after October, we could start seeing that EB2 will move faster. And that is exactly what we are seeing since the November 2021 visa bulletin was just released, Thorny.
Right. So would that be the only update then? That EB2 is moving
forward? So that is the main update. I mean, you have the USCIS routinely updating their forms. They have become very strict and they no longer allow the use of older forms that have expired. And sometimes they are literally, updating forms like this month to start becoming effective from 1st of November. So it's not much time. And for people who are doing their own work or working without a lawyer, or sometimes even with lawyers, it's easy to make mistakes and use the wrong form. And then after 3 or 6 months, your entire package is returned to you. It is rejected because of using the old form that is not valid or applicable. And so you could end up, if the priority dates roll backwards, for example, you could end up losing a lot for you and your family. So please be careful. Sometimes small mistakes can cause major complications in life.
Right, right. So, Ms. Murthy, I'll go ahead with the H1B FAQs for the show then.
Sure, yes, let's go ahead, please.
Right, so some of the FAQs that we've designed for the show, I'll start off with them. What is consular processing, Ms. Murthy? Can you explain our viewers that?
Got it. Okay, so we use the word consular processing. Generally, consular processing or CP is used in an immigrant visa case, but if you're using it in the H1B context, then the correct legal term is not consular processing, but consular notification, where the employer or the USCIS sends the package to the consulate, notifies the consulate so that the individual employee can apply for the H1 visa stamping or L1 or whatever the visa stamp at the particular US consulate, for example, either in Hyderabad or Chennai or Kolkata or Delhi or Mumbai if it's in India, because I know you're taping this in India late in the evening. And of course, in the US, it's whichever country you're a citizen of, that particular country, the consulate closest to your permanent address in that country would be the applicable consular post for notification with respect to, because of the fact either that the person has not maintained valid legal status in the US, or the person is anyway traveling abroad when there's a change of status pending. So the exchange of status is no longer valid, and USCIS has no option but to send it to the consulate for consular notification. I hope that was helpful, Tarni.
That was, Ms. Murthy. So how much does this cost, and who has to go through this? Who are the people who wait for consular notifications, and what is the procedural cost involved?
So the main procedural cost, as with all processing, if it's at the consulate, then you pay it in Indian rupees. So it depends on the currency conversion between the US and also what India charges for US citizens. It's called reciprocity schedule for a lot of the visa fees across the globe. So sometimes you may say, how come this country has only so much in fees? Guess what? That country is only charging a smaller amount for their citizens to enter that country for US citizens. So the US follows what they call reciprocity. If India charges a high fee from Americans, then America says we will charge the same fee that you charge our citizens, we charge your citizens. So the fees are usually in rupees, and it is based on, it's not the immigrant visa. The immigrant visa fees tend to be obviously much higher, but the non-immigrant fees tend to be lower. The forms, the fees keep changing. They're mentioned on the DS-160 form when you fill it out, the process. And once you complete it, if you change the date a couple of times, you shouldn't have to again pay the fees. The same fees will be valid for the entire process. And sometimes beyond even 1 year, they renew it or extend it like they did during COVID-19. But generally after 1 year, if you again refill a fresh DS-160, you have to pay the full fees again in Indian currency, but based on the US conversion for filing and obtaining the non-immigrant visa.
Right. So, Ms. Murthy, is it difficult to get an H1B visa if the person is residing outside the US compared to people living inside the US?
So let's use the correct technology terms here, Thorny. So when you use the word visa, visa means the person is outside the US and is applying for a visa stamp at a consular post. If you're inside the United States, then the correct legal term technically is called status.
My bad. Thank you.
I will get an H1. Pardon?
I said my bad. Thank you for correcting me.
No, it's not correcting. These are common mistakes that many lawyers make, let alone somebody like you that's trying to be the best possible news anchor and MC in this show. So I don't expect you to know every nuance of immigration law that's out there. So the very fact that you know as much as you do is very impressive and noteworthy, Tarni.
Honored. Thank you, ma'am. So you were saying
Great. So it's just the difference. Status visa is what you apply from abroad. The status is what you get from within the US. So if I'm changing from a student to an H1B within US, I don't have to go outside. I don't have to go abroad. I can do the change right here in the United States and switch from F1 student to H1B. And I don't have to go and get a visa stamp in my passport to start working legally from October 1st if I'm a CAP subject case. If I'm a CAP exempt case, then I can file it anytime with any start date. And you're not subject to, the only time you have to go to a US consular post for consular notification or consular processing, of course, is if you're either out of status or you're traveling abroad, and then you have to travel and get the visa stamp and come back on a fresh status if your prior visa stamp in your passport has expired, has already terminated. But if you have a previous H1B visa stamp with a prior employer, let's say from 2020 to 2023, then even if you change jobs, get a fresh H1 petition approval, you can use that old visa stamp, show the new petition approval at the port of entry, at the airport, land port, or seaport. It's called the POE, the US port of entry, to the CBP, the Customs and Border Protection, and get the fresh I-94 card, which is no longer a card, but it is online, given to you for the next 3 years that you, let's say you have a new fresh 3-year approval. Some of these terms are a little confusing and technical, but of course, those who are going through the process will find it much easier because you're already seeing what is happening on a daily basis.
Right, which brings me to my next question, Ms. Murthy. What happens when one travels during the H1B registration period? Does it affect their lottery chance?
No, there is no problem if you're traveling during registration period, because during registration, the employer is not actually filing an H1 petition for you. It's only when the petition is actually filed with the USCIS, then travel, especially a change of status, is not permissible because a change of status is deemed abandoned by law upon departure from the United States. But that has nothing to do with the pre-registration or the registration period, Porni.
Right, so it's important to stay, not travel probably after the H1B petition is filed, especially for non-immigrants then.
That is correct.
Right.
Until it is approved.
Until it is approved, right. So, Ms. Murthy, what information must the employees provide as a part of the H1B Cap registration process?
The employee or the employer?
The employer, I'm sorry.
Either one. Okay, so the employer files the pre-registration package, but they use the name, the job, the title, whatever the information, the person's passport number. There's a very limited amount of information that is required: the name of the employer, the name of the employee, the date of birth, the passport. So they don't really get into a lot of the details. It's only once that the person is selected in the pre-registration, then you have to fill in the entire information for the H1B labor condition application, the LCA, with the Department of Labor, and the H1B petition, the Form I-129, with the supplement H for the Form I-129, and explain the job duties, the salary, the detailed job description, the location of the work, what is the minimum required for the job. For example, bachelor's or master's degree, how many years of work experience, is it of level 1, level 2, level 3, or level 4 wage job, because that will determine the wage level for that particular job. So a lot more details with the petition, very, very skeletal / minimal information with the registration. It's mainly for the USCIS to pick who is going to get selected so that they can provide additional information, so that they have that 90-day window, 3-month period of time to file for a new H1B with all of those H1 petitions with caps, which are cap subject, can only have an October 1st start date, which is the first day of the new USCIS fiscal year.
Right. So, Ms. Murthy, this brings me to my next question. I mean, this is frequently asked, I'm sure, but I found it a little unusual. Is it, easy to get, is it difficult or probably easy to get H1B visas for certain jobs in comparison to others?
So actually, it's not the jobs. Most people say, oh, I can't get an H1. I'm not a computer scientist, or I'm not, doing science or, electronics engineering or whatever, masters in information systems. But you don't have to do that. I can be an English graduate or a history graduate, like I was, for example, and say I'm going to be teaching history. No problem. That's an H1B specialty occupation, to be a school teacher or to be a college university professor in teaching history or English language. Or for you, for example, working as a reporter, let's say you've got a bachelor's in media and media sciences and communication, and that's your bachelor's or master's degree, and you come for a job specifically working in that field, no problem. All that the USCIS requires for an H1 is it has to be in a specialty occupation, and that needs to have a minimum of a bachelor's degree for most people to perform that job. And if that is the case, then you use that person's education and the credentials and describe the job duties to show why it's sophisticated and complex and requires minimum the attainment of a bachelor's degree or higher education in order to perform those complex specialty occupation job duties. So it's not whether you have a bachelor's in history or English literature or science or medicine or engineering that's important. How does that particular education connect with the job duties? And is there a need or requirement in the United States? We know that there is a huge vacuum in the STEM fields, science, technology, engineering, and math. So those are easier in that sense, but it is not that the law prevents or requires that for an H1B Torney.
Right, so it's probably a little easier for the STEM industry people, the science, technology,
there's more
engineering,
demand,
management, right? Because
there's just more demand for it.
There's a major amount of population probably in that area. Right, right, Ms. Murthy. So
Correct.
what
we
happens?
have a huge shortage in America.
Right, yeah. So Ms. Murthy, what happens when an employer terminates a person's H1B? How much time do they have
So there are
in the US?
Oh, yes. So there's actually, they changed the rules and there's some clarification where they've said you have up to 60 days from the day of either resignation or job termination or quitting or being fired or whatever to find another employer and file a change of H1B jobs. Fortunately, that was the change with the, when they changed literally the very last day of President Obama's administration on January 17, 2017. That we had this, 60-day grace period. Before that, there was no grace period whatsoever. If the employer terminates the employee before the full H-1B term requested, then the employer is required to pay the one-way airline ticket or offer that airline ticket to the employee to return home. But it's only to the principal employee, not family members. And a lot of employees do not accept it because they want to find another job in the United States. They want to continue to work. And so most of them say, no thanks, but no thanks, I'm not interested. But the employer is supposed to offer that and notify the USCIS and revoke the H-1B petition effective so that they do not continue to remain liable for payment of salary and benefits to the H-1B employee that they have presumably terminated for whatever reason.
Right, right. Ms. Murthy, so this actually brings me to my next question. How does the transfer of an H-1B work, no matter what the case?
So the transfer from one employer to the other,
right.
If a person is cap exempt, meaning you're switching because you had a prior cap subject petition that was approved. Now you are cap exempt, you switch from employer A to employer B. Employer B now explains your new job title, your new job duties, your salary, your work location, explains how you are qualified for the job. And they just check off the box, checking off new employment, change in previously approved employment. Usually when you're changing an employer, you're supposed to do new employment. If you're changing job duties or job location with the same employer, then you can say change in previously approved employment. And you file it, and USCIS takes their own sweet time in approving the case. It could be weeks or months, most likely. It used to take 2 to 3 months before the whole premium processing thing started. But once they decided they can make thousands of dollars off of employers' backs, they started taking 6-8 months for the same H1 petition that previously used to take 1 to 2 months. And but the good news is, of course, while it's pending, the employee, when they change from employer A to employer B, the employee can continue to work as long as that H1B petition is pending with the USCIS, even if it's pending for a year or 2 years. The limit of 240 days or 8 months is only applicable if it's an extension with the same employer, which is actually almost defies common sense and logic, because that law was prior to the law giving AC-21 portability benefits. So it looks like USCIS's laws and regulations, their policies are outdated at this point.
Right. Ms. Murthy, this brings me to a very frequently asked question. I'm sure you're tired of hearing this, but I'm still going to ask you this. Why are the USCIS processing times so long? I'm sure you hear it from almost every client of yours.
No, yeah, it is long. And the reason it's long is because under the prior Trump administration, they decided that their goal, it seemed to me that their goal was how to harass employers and employees and purposefully delay immigration processing. Even a lot of people who voted for the prior president were very disappointed with, especially employers and businesses that believed that the Republican administration would be much more favorable and sympathetic to businesses and companies, were surprised by the positions taken by the Trump administration, which truly almost went backwards and made it very clear that they couldn't be concerned that they thought that their goal was to almost deny every case, deny extensions, issue RFEs, put as many roadblocks, rather than acknowledge that there is a clear shortage of certain positions and certain skills within the United States. And actually, there's so much research that shows that H1B employees increase the wages and working conditions for US employees, that every one H1B creates 2 new jobs. And so why they take forever and a day, I think it's more attitude, it's lack of resources, but I don't believe in lack of resources because they have so much money, their fees keep increasing, the quality of service keeps reducing, and they channel away all the money that is being paid towards enforcement, which was made very clear when the USCIS was created under the Homeland Security Act of 2000, back in 2003, after the September 11th tragic attacks on our country. At that point, the goal was that the USCIS would focus on service, exclusively focus on serving employers, employees, individuals, and families. But in fact, they forgot their mission and their goal, and they're acting like they are a government bureaucracy whose main goal is to put roadblocks, to delay and not approve petitions and applications, which is very much against the core of why the USCIS was created back in 2003. So why are they doing it? I think it's a lot of gamesmanship. It's playing, it's abusing and misusing the system. It's taking your client's money and not having the ethics and integrity to provide service that you are supposed to provide. If I take your money to give you a consultation, I cannot make you wait 2 years for that consultation and then use up the money and say, well, I don't have any more, I'm going to increase the fees. And if you want the service, you have to pay me an extra $2,500 for premium processing to do the job, which I should have done in the first place without paying for that extra money. So why do they do it? They get away with it. It's the federal government. It's difficult to sue the federal government acting in its sovereign capacity. There's something called doctrine of sovereign immunity. Governments are generally protected across the globe for acting in their while acting in their governmental duties and doing government functions from private lawsuits. But I think when someone takes our money and does not provide services, they should be held accountable. They should be sued. They should be made to provide services, because it is almost illegal, unethical, and feels like daylight robbery when someone takes your money and doesn't provide you any of the services that they were supposed to provide you with. So I know you're getting me off on a tangent, but
No.
I really get upset with what I consider to be lack of ethics and integrity on the part of our government to take money from employers, families, individuals, many of whom can ill afford it, to provide mediocre or below average services. Because if you and I in the private industry did that kind of work, we would be fired by our clients and we would be without a job. So I want to ensure that our government does the job it's supposed to do and is held accountable, because all citizens and all agencies within the United States are responsible ultimately to the people who vote politicians into power, and we have the right and expect to get good service for valuable money that we all pay.
True that, Ms. Murthy, and it only shows your credibility as an attorney, to say all of this. I understand the research that went into the statements that you've just made, but we have a caller on hold, Ms. Murthy, Mr. Rama from Maryland. Hi, thank you for calling, Mr. Rama. You may ask Ms. Murthy your question directly.
Hello, madam. Thanks for Sakshi TV for taking my call. Madam, I have two 140s. One of the 140, like it is approved in 2010, and I moved to a new employer in 2015. My old employer revoked my 140 in 2016, around 2016 January. So in 2017, my new employer applied GC process and got the approval with the 2017 priority date. Even though we requested to port the date, they did not do it. Even after the correction also, they didn't do it. So when I'm eligible for 485 last year, we applied 485 with the priority date of 2010. They accepted my application and also gave receipt number with 2010 priority date. So my application is still pending, and I got a doubt about this and got a Freedom of Information Act document. So they have handwritten 2017 priority date on office use only section. So could you please tell me, like, what can I do on this kind of scenario?
So you're saying the USCIS has made a mistake, Rama, in giving you a 2017 priority date when they should have ported the old priority date. So you want to attach a copy of the law, copy of the legal arguments as to why the government is making a mistake and giving you an old priority and giving you a new priority date instead of porting the old priority date. So the lawyer has to make a legal argument, because sometimes what happens is there's a lot of turnover, a lot of new employees. Many of the immigration officers do not understand the nuances, the complexities, the changes. I've been doing this for 30 years, and I can tell you there are so many gray areas in the law, and we do it morning, evening, night. And you know, a lot of these immigration officers have 1 month, 6 months, 2 years experience. How can they know every detail of the law? So whoever the lawyer you have, the company's lawyer, needs to attach a copy of the law, copy of the arguments, and explain why a new receipt notice should be issued with the correct priority date. Circle it, put the correct priority date, attach a copy of the law, attach a copy of the regulations, make the legal argument, and send it to USCIS. And attach the copy of the January 17, 2017 USCIS regulations that were finalized that clearly allow the porting of the priority date as long as the I-140 was approved and valid for minimum 180 days. Then even if it is revoked, it should not matter. You can still extend your H1 petitions, and you can use that previous I-140 approval to port the earlier priority date. So clearly somebody is not understanding the law here, Rama, and ultimately it is up to you. And if your company lawyer doesn't have the knowledge, the ability to do it, then feel free to contact us at murthy.com to request, to file that, to make the legal arguments, to attach a copy of the law and the memos, and basically what we do is we go point by point by point by point explaining why the government is wrong or incorrect and why they need to give Rama the old 2010 priority date instead of the 2017 priority date. Good luck. I hope it works out for you, Rama. And if we can help, don't hesitate to contact us at law@murthy.com.
Right. So, Ms. Murthy, I just want to say something in relation to what you've said earlier before the call. The Trump administration's wrongdoings have caused rather harsh effect on the non-immigrants, and I hope the Biden administration is working on improving it. So what would be your golden immigration message to all of the immigrants in relation to this, if you'd like to say something?
Sure. Are we running out of time? Are we getting ready to wrap up as always? It's like the time just flies on us, right?
Right, it always does.
My golden rule. Yes. I know the time really flies. Well, my golden rule about immigration, about life is, don't think that the world owes you anything. The world doesn't owe us anything. We have to demand and fight for justice and for what belongs to us. So in this example that Rama gave, he can't just expect the government to do its job because it's not their life. My father used to always tell me, Sheela, you have to fight and demand what you want. Don't fight with us. Don't argue with your parents. Use your arguments and your knowledge and your guts and your confidence to demand from the world. And I took him seriously, and I continue to fight for justice, for the rights of other people. And don't ever think that you should not fight because it will cause problems or complications. If you don't fight for you, then who else will fight for you?
Right.
Believe that you are owed happiness and you're entitled to it in life. Demand it. And if you don't get it, sue if you have to get the justice and rights that you deserve, especially in this country, which is a democracy and which believes in the freedoms and choices for you and for your family. All the very best. Good luck. I hope it works out. And I look forward to seeing you all next week.
Right,
Same
that was
day,
sound
same time.
advice. Thank you so much, Ms. Murthy. It was a privilege hosting you. You're watching Sakshi TV Live with me, Torni Makana. Thank you.